Thank you. Representative Rosendale, you're recognized for 5 minutes.
Thank you very much, Chairman Bost. The Constitution is clear that the legislative branch, not the executive branch, writes the law. For too long, Congress has abdicated its responsibility by allowing unelected bureaucrats to promulgate rules that go further than the underlying statute passed by Congress provides. Many in Congress, unfortunately, are okay with this dynamic because it allows us to escape making any difficult decisions. Since 1984 case of Chevron USA, Inc. versus Natural Resource Defense Council, Inc., federal courts deferred to an agency's interpretation of an ambiguous law. This flawed ruling set our country back significantly. In 1984, our total public debt was 40% of the gross domestic product, and now it is 121%. The country has suffered immensely from members of Congress ceding our authority to the executive branch. The Biden administration has been particularly egregious in abusing the court case by claiming that a 2003 law intended to help service members provided for the pretext of their unconstitutional student loan redistribution scheme. The VA has abused its authority to provide abortions despite Section 106 of the Veterans Health Care Act of 1992 specifically prohibiting abortions. The Supreme Court, through Loper Bright Enterprises v. Raimondo, rectified the flawed decision from 1984 by telling federal courts not to replace their judgment with an agency's judgment. The American people sent us here to do our job, and now it's time for us to pass clear legislation that leaves little interpretation to be abused by bureaucrats. If you allow others, whether they're unelected judges, as the ranker said, or unelected bureaucrats, as folks on this side of the aisle have been recommending, to make decisions about the implementation of policies, you've abdicated your responsibilities. It doesn't matter which group of these unelected bureaucrats we defer to. It is wrong. Write the laws tight and don't grant rulemaking authority. Or, as Dr. Wallich says, amend it and refine it. And that way we can improve it and make sure it is being implemented the way that we want it. We cannot be lazy legislators and think that laws will be implemented the way that we think or that we hope they will be. And finally, put more people on committees that they are qualified for instead of the committee that they can raise the most money in, because that takes place every single day in this organization as well. Professor Squitieri, please elaborate on why the Loper Bright Enterprises Raimondo decision is good for Congress.
Congressman, I think it's good for Congress because it tells Congress that they can't just kick the can really anymore. There was an incentive, I think, in the past to just write vague laws and hope that a congressman's friend and the agency will interpret it as the congressman likes, and particularly with congressional staff bouncing back and forth between agencies. Now the political calculus has changed where a legislator says, well, this law is not going to be interpreted by my friends half the time or non-friends the other half the time. It's going to be interpreted by a politically neutral judge. So I think that gives the incentive for Congress to, yeah, it might take some hard work to hammer out a solution in the text of legislation, but to go ahead and do that because a judge is, going to give that interpretation its best reading and not really let politics come into play.
Thank you. In your testimony, you mentioned Congress should recognize the limits of the case and go further. What do you mean by that?
Oh, in particular, Kaiser deference. I think it's debatable whether that was affected by Loper Bright. I take the position that it probably was not. But this committee could solve that today and say, no Kaiser deference across the administrative state would be fantastic, but the VA in particular.
Okay, I contend that we should write laws much, much tighter, refine them as we get information, and yet we have members of the Veterans Administration that came before us just yesterday requesting additional latitudes. How do you feel about that?
With agencies requesting additional latitudes?
And flexibility so that they can do their job easier, better.
Well, I would say, and I think this is an important point, that there is, it's philosophically debated, but there's a distinction between law and policy. And Loper Bright is not supposed to limit agency policy discretion really at all. It only limits agencies' authority to interpret the law, but agencies still have authority to make policy discretion. So to the extent that agencies are asking for more policy discretion, I'd be skeptical that they really need it. And if it were to be granted by Congress, I think Congress should include factors, say, okay, yes, we'll give you this discretion, but you must consider X. You can never do Y, things like that.
Thank you so much. Thank you very much, Mr. Chair. I yield back.